Hello, I'm Charlotte McMurchie. I'm a partner in the real estate disputes team here at Muckle, and this is a lawyer's guide for commercial landlords. Landlord and Tenant Act 1954 is an important piece of legislation for landlords because it gives a structure to how the lease operates. The landlord, if it's having trouble negotiating terms with a tenant, can simply terminate the lease with a Section 25 notice. So there are some really useful things in a landlord's armoury to get the outcome that they want. The Landlord and Tenant Act 54 was introduced to ensure that there was some element of security of tenure for the tenants, that there was an opportunity to have a renewal as a right of their business tenancies. The terms would ultimately be decided between the parties, but they weren't forced at the end of their 5-year or 3-year or 10-year lease to simply up sticks and leave, because that interrupts business continuity. It's important to have a commercial tenancy agreement in place so that both parties know exactly what their rights are. That's not to say if you don't have something in place that you won't have any rights, either as landlord or tenant, but it's more arguable from either party's side if you've got no piece of paper, if I can put it as boldly as that, on which to rely. If you don't have a written agreement, then from a landlord's point of view, if the tenant is occupying for the purposes of a business, then they are more likely than not to have accrued 1954 Landlord and Tenant Act protection. So that means that the tenant will then have an automatic right to renewal of that lease. For a landlord, that may not be desirous. They may want to have sort of fixed terms so that at the end of the fixed term they can assess who they want in there and what they want to do with the property. Dilapidations are a claim that the landlord has in respect of the tenant, and it all revolves around the repairing obligations, the decoration obligations. So whether or not the tenant has allowed the property to fall into disrepair is essentially what it is. And the landlord can come in mid-term and have a look to see whether they're keeping up to date with their repairing obligations. Or more likely is that the landlord, at the end of the fixed term, when the tenant is going to leave, or the tenant's coming up for renewal, that they'll want to check out the condition of the property and reach an agreement with the tenant about the cost of that repair and whether or not the tenant's going to physically put it back into its rightful condition, or whether the tenant's going to make a payment for the costs of putting it back in the right condition. Rent reviews usually are put into longer-term fixed tenancies where the landlord wants to get, without renewing the lease, an uplift on the rent that's being paid. Usually there'll be upwards-only rent increases, and there are mechanisms that are drafted into the lease that explain how the rent is to be calculated. If you've got a rent review dispute, there can be a number of levels to it. The first could be that the landlord hasn't activated the rent review in accordance with the terms of the lease. So you need to look at the lease to see what the mechanisms are and what the provisions are. The key one to look out for is whether or not time is of the essence, and by that I mean, is there a time frame within which the rent review has to be instigated? If there is, and you don't instigate it within that time period, then it's arguable that you've lost your right to review the rent. Covenants in a lease are basically promises from the landlord to the tenant and the tenant to the landlord, so that you will either do something, so an obligation, say for the tenant to pay the rent, or that you will not do something. So on the landlord, it's that they won't interfere with the tenant's use of the property, so that it's known as their quiet enjoyment. If covenants are breached, and usually this is a landlord to a tenant, so if the tenant, the easy example is the tenant fails to pay its rent, there will be in the lease, or there should be, a provision that entitles the landlord to bring the tenancy to an end because of this fundamental failure, and that's called the landlord's right to forfeit. So for a tenant, failing to pay the rent can be catastrophic. If the tenant breaches any other covenants, it's still actionable by the landlord. So failing to repair is also something that could give rise to a termination of the lease. We've helped an awful lot of commercial landlords and tenants deal with skirmishes, shall we say, with the other party. People have come to us as a sort of preparatory measure, an investigative measure, but also when they're either in receipt of a claim or want to issue a claim for breach of covenant. We won't just give you the law, we will give you the law but framed in a commercial way, giving you options. We want to find out what it is that you want as the outcome and then do our best to get you there. I hope you found that useful, but if you would like any more sort of bespoke advice, then please do contact the Muckle team and we'll be very happy to help you.